Oh yay, oh yay, oh yay. The Honorable Court of Appeals for the 11th District of Texas is now in session.
Thank you, Mrs. Williamson. Good morning. Want to tell you first kind of where we are on these things is that I'm sure by now that the two attorneys have participated in several Zoom proceedings for court. Well, you are in our inaugural session of a Zoom proceeding today. We would have done it sooner, but for the fact that this ransomware attack that hit the appellate courts took us out of our records and our network for about 2 months. And so we're back on our feet and ready to take care of these cases. As demonstrated a minute ago with Mr. Dorfner, if there is a problem, one of the ways to fix it seems to be have you step away or exit and then come back in. If we have that situation, we'll certainly pause the timer and not count that time against you. And if all else fails, pick up the phone and call the court, and we can do that. The clerk's office is open. They will be in contact with Ms. Williamson and she will help. Before I begin, I would say that we need to recognize Ms. Williamson for all of her hard work to get this taken care of. We needed to do a lot of technological things. I believe she met with y'all on Tuesday to test out our procedures and see. John Bailey, of course, is displayed on the display for my name. I'm joined today by Justice Keith Stretcher from Midland. He's here at the court for the argument. I'm also joined by retired Senior Chief Justice Jim R. Wright, who is sitting with us from Mike Wilson's place. He is also at the court as well. We're in different places despite our similar backgrounds. But if you'll bear with us, like I say, you likely have a lot more experience doing this than we do. So with that being said, we'll proceed with calling our first case today. Oh, I would also add that you may see some folks appearing in the screen. We have some briefing attorneys or clerks that are staff attorneys that are serving as some facilitators to assist us in this endeavor, and we appreciate their efforts as well. So and the final note, we are broadcasting this on YouTube. I believe, at least on my screen, it says that we're live on YouTube now. Just want to caution you to let you know that the public that chooses to tune in, I can't imagine why they would, unless they were a party interested in the case. But that is ongoing as we do this. So with that, we'll call our first cause, 11-19-309, Marco Davis individually on behalf of Motley Capital versus Gulf Coast Authority. Mr. Dorfner, are you ready to proceed?
Ready to proceed, Your Honor.
Please start.
Thank you, Your Honor. As you mentioned, my name is Aaron Dorfner, and I represent Marco Davis and his LLC, Motley Capital LLC. We're here today on appeal from the 244th Judicial District Court in Ector County after it denied a Texas Citizens Participation Act motion to dismiss that I filed on behalf of the appellants. This controversy began when Mr. Davis told the Gulf Coast Authority, a political subdivision of the state of Texas, it could not cross his private property or build on the surface of an easement that had been granted to the city of Odessa. After he told the governmental entity that they could not do what they wanted with his property, they sued him as a result, not just to resolve issues over access to the property, but to stop him from quote unquote denying their rights and preventing them from using his property. In addition, they sued Mr. Davis for a crime, a criminal violation of the Water Code. This is a classic retaliatory lawsuit that the TCPA was enacted to prevent and offer a motion to dismiss the clause. Today, I wanted to speak on a few issues. First of all, is the issue of whether or not the trial court even had jurisdiction over this matter in the first place. Thereafter, I'd like to discuss that if there was jurisdiction on any cause of action, that the TCPA does apply. if the TCPA does apply, the Gulf Coast Authority failed to demonstrate by clear and convincing evidence the prima facie case of all of its necessary elements in order to succeed. And on top of that, the defendants established their defenses as a matter of law and should have been dismissed from the case. In summary, there is no jurisdiction because the trial court did not have jurisdiction to consider Gulf Coast's request to enforce and expand the city of Odessa's property rights that were granted by Motley Capital's predecessor. There was no jurisdiction for declaratory judgment action. There was certainly no private cause of action and no jurisdiction to allege and bring a criminal action against Mr. Davis. And there's no jurisdiction because the Gulf Coast Authority did not demonstrate that it suffered an injury when the pipeline was broken. If there is jurisdiction, the TCPA applies because Mr. Davis and Motley Capital were sued for telling the government that it could not use their property, which qualifies under the TCPA as both the right of free speech and the right to petition as those terms are defined in the Act. First, a few facts to give the
Mr.
court.
Dorfner, excuse me.
Justice Bailey.
Are there any, do you know of any other cases where this jurisdictional issue has come up on the interlocutory appeal, that there was the assertion that there wasn't ever any jurisdiction in the trial court to start with?
I do not, Your Honor. I'm relying on the Supreme Court case law and other contexts, of course, that says that jurisdiction can't be waived and can be raised at any time and even on appeal. And I believe it's appropriate for this court to consider the jurisdiction, even in the first place, that the trial court did not have over the certain causes of action.
Okay.
By way of background, in 1961, Motley Capital's predecessors granted an easement to the city of Odessa. The easement reserved the surface to the grantors. And it said that the surface could be used by the grantors so long as it did not interfere with the city of Odessa's rights granted in the easement. Sometime after 1961, a pipeline was constructed, and that pipeline was to take sewage water from the city of Odessa to a treatment plant on South Dixie Road in Ector County. We fast forward about 35 years to 1996, and the record demonstrates that the city of Odessa gave the Gulf Coast Authority a license to operate the pipeline. The license purported to grant ingress and egress to the easement over and across from a public road or property owned by the Gulf Coast Authority. The license excluded any interest in the surface estate. The license went so far as to say any construction on the surface of the easement had to be returned to the state that it was prior to construction as practically as possible, and there could be no permanent changes to the surface of the easement because of that restriction. The privileges that Odessa granted to the Gulf Coast Authority exceeded what was given to the city of Odessa in the first place in 1961, which only provided that the easement allowed for the construction and maintenance of a sewage water disposal pipeline. There were no rights of ingress and egress. However, that's not an issue for today. What's at issue for today started in 2018 when Motley Capital hired a company called Rio Services to grub the vegetation off of its yard and put down 6 inches of caliche. During that construction, there were problems with the pipeline. Gulf Coast Authority alleges that the pipeline was broken by Motley's contractor. After the pipeline was broken, the Gulf Coast Authority and its contractors occupied property in Motley Capital's yard outside of the easement. And it's referenced in the petition that Mr. Davis at one point even asked when he could use his property. Even more of the problems begin in June of 2018 when Mr. Davis observed Gulf Coast Authority's employees coming into his fenced yard, crossing his property, and not on the easement. Mr. Davis confronted them and said, "You need permission to cross my property. If you don't get permission, you'll be asked to leave. And if you don't leave, we will file trespass charges against you." After that, we received a letter from the Gulf Coast Authority demanding that Mr. Davis pay $400,000 in damages. That was in June of 2018. In August of 2018, an employee of the Gulf Coast Authority named Chuck Harris told Mr. Davis that state law required that bollard poles be built around the manholes. Along the sewer line, there are manholes on the surface of the easement. A Gulf Coast Authority employee told Mr. Davis, "We have to construct bollard poles because state law requires that." In fact, during this litigation, it was conceded by the appellees that state law does not require those bollard poles to be constructed. Nevertheless, that alleged state law was used as a pretense to go onto Motley Capital's property and build those bollard poles. The appellees have even supplied the court with a photograph of the bollard poles, which consist of steel piping filled with cement, what we would term permanent construction on the top of the easement. Nonetheless, in February of 2019, Mr. Harris contacted Mr. Davis and said, "We want to build more bollard poles around the manholes." Mr. Davis said, by this time, he said, "Anything that's going to be built on the surface has to be approved by me. And what's the state law that requires building these bollard poles?" Mr. Harris did not supply the state law, and they sent another letter asking for access. Or an email, I should say. There was email correspondence, and that's in the record. Important for this appeal is the fact that Mr. Davis offered access to the Gulf Coast Authority to work on its pipeline. In fact, I wrote a letter in February of 2019 that said, "We will comply with the rights granted in the easement for access." But that wasn't good enough, because in March of 2019, the Gulf Coast Authority sued Mr. Davis individually and sued Motley Capital, his LLC. In the petition, they asserted that they're a political subdivision of the state of Texas. They included, as I mentioned, a criminal violation of the water code, a declaratory judgment, a request for injunction, a claim for negligence, and various causes of action against Mr. Davis individually and his company. This was not a straightforward case in order to determine access to the property or something other than that. This was a punitive lawsuit to punish Mr. Davis for telling the Gulf Coast it could not cross his property and it could not build on the surface of his property. Now the suit even made requests.
Counsel, if I could,
Yes, sir.
we need to make sure that we talk about all the communication prior to the conduct, because I'm sure you're aware of that line of cases that say the TCPA doesn't apply to conduct, it only applies to communication. And I want to make sure that I ask a lot of questions sometimes, and sometimes I wait to the very end, but I want to make sure you get the opportunity to explain your position that these are communications prior to the conduct.
Yes, Your Honor. So this court held in the ETC Texas pipeline case that we look to the petition as evidence of whether or not this case is related to the TCPA and those communications. So the communications that I would point to is the fact that when the Gulf Coast Authority employees came onto the yard, Mr. Davis said, "You can't cross my property without permission. You've got to clear it from me." So that was a communication and not just conduct. I wrote a letter saying, you can't build bollard poles. Mr. Davis wrote an email that said you can't build bollard poles. These communications are both qualify as the right to petition and the right of free speech as those terms are defined under the TCPA.
And counsel, these communications were prior to the conduct of building the poles, is that correct?
Yes, there was communications prior to building one set of poles. Then there were more communications after the poles were built in August of 2018. They asked to build more poles, and there was communications that said you cannot build more poles because state law does not require that. And the easement says the surface is reserved for the grantor. So there were communications both before the bollard poles were constructed and communications after the bollard poles were constructed because there was a request for more. Those communications qualify as communications under the TCPA. The TCPA protects citizens who associate, petition, or speak on matters of public concern from retaliatory lawsuits to silence them. That's exactly what was happening here. This qualifies as a right to petition because Mr. Davis communicated to a governmental entity about the use of his property. And that qualifies as the right to petition both under the US Constitution and under the Texas Constitution. It's obviously in the First Amendment of the United States Constitution. It's also in Article 1, Section 8 of the Texas Constitution that says every person shall be at liberty to speak, write, or publish his opinions on any subject. Telling the government you can't use my property because you don't have permission qualifies as the right to petition. Article 1, Section 27 of the Texas Constitution says that citizens have the right to apply to those invested with the powers of government for redress of grievances or other purposes by petition and remonstrance. So this qualifies under the definition of right to petition in the TCPA. In the Long Canyon case cited in my brief, the Austin Court of Appeals said that subsection reflects the legislature's intent that the definition be consistent with and incorporate the nature and the scope of the right to petition established in constitutional jurisprudence. So the essence of the right to petition is to tell the government, no, you can't cross my property. No, you can't build on the surface of my property. No, you can't take my property without repercussions. That's the essence of the right to petition. That's what the constitutional jurisprudence says about the right to petition. And the TCPA protects a person from being sued when that person exercises those rights. Mr. Davis petitioned when he told the government he could not construct barriers on the surface of the easement. Mr. Davis petitioned when he told the government, the Gulf Coast employees, it could not cross his property. An owner of realty has the right to exclude all others from his property. In the Lightning Oil case, the Texas Supreme Court said that is one of the most essential sticks in the bundle of rights that's commonly characterized as property, exclusion from your property. Now, this is especially important when the government does that. And when the government tries to come onto your property, when the government wants to build on the surface of your property, when the court looks to the easement and the license, there's no right to build on the surface of the property. When the government did that, even the small footprints that are those bollards, that's a taking. There is a way for governmental entities to take property from private citizens. It's through eminent domain, it's from condemnation, it's not by way of a retaliatory lawsuit, it's not by way of a declaratory judgment suit, it's not by way of circumventing a license agreement with someone that's not even a party to this suit. So Odessa's license restricted Gulf Coast Authority's privileges that it could do on the property, what actions it could do. When it said you have to return the surface to the way it was before there was construction, that means there can't be permanent surface construction. This goes back to my jurisdictional argument. Odessa is not a party to this suit. Odessa is not here. Odessa was not involved in this litigation at all to help decide what the terms construct and maintain in its easement and license mean. The Gulf Coast Authority wants to expand those meanings to say, well, even though Odessa said we have to return the surface of the property to the way it was before construction, even though the license says that, that's not what it really means. It means we can build on the surface of the easement. Well, Odessa is needed for that determination. Odessa is needed for, that's the jurisdictional component of standing. That's the jurisdictional component of having all parties before the court in order to afford complete relief. Without Odessa, that can't happen. That's why there's no jurisdiction for the declaratory judgment portion of it. So when Mr. Davis refused to allow Gulf Coast to do whatever it wanted to do, he also exercised his right of free speech, as that term is defined under the TCPA. So free speech is defined as comments that or communications that touch and concern various interests. Included in that are governmental interests and economic interests. Under the TCPA, the right of free speech includes communications made in connection with the matters of public concern. It is our contention that when Mr. Davis said, don't cross my property without permission, ask me permission before you do that, don't build on the surface of the easement because the surface is reserved to my predecessor and to me, that's exercising free speech. It implicates the government's rights to use private property. So it qualifies under a governmental interest under the definition of the right to free speech. It also has to do with economic interests, as the court is well aware, and that property is less valuable if more people can use it. If there is unlimited rights to ingress and egress to Motley Capital's property, that makes his property worth less money. So what the Gulf Coast Authority is asking for, the trial court, was a declaration and an injunction to stop Mr. Davis from telling them no. Those things are directly related, and we can see that in the petition. I quoted that in my brief. There are direct connections from the communications that Mr. Davis made to the Gulf Coast Authority and to what they sued him for. And therefore, the case should have been dismissed by the lower court. The TCPA applies. I'm running out of time here. I'll leave it to my brief for the rest of the argument, unless the court has any questions. But we also contend that the Gulf Coast Authority, because the TCPA applies, the Gulf Coast Authority did not establish each and every essential element of its causes of action. They did not make a prima facie case. So we ask the court to reverse the trial court and render a decision in favor of the appellants.
Thank you, Mr. Dorfner. Mr. Greenhill, are you ready to proceed?
Yes, Your Honor.
Go ahead.
Good morning, Your Honors, and may it please the court. The primary issue before this court is whether the TCPA applies to Gulf Coast tortious interference and declaratory judgment claims. The trial court correctly determined that it did not, because this case is a private dispute about the scope of an agreement. Davis, however, wants to use the TCPA as a means to deny Gulf Coast its day in court by claiming that its suit somehow implicates its right to free speech and to petition the government. But this case has nothing to do with Davis's constitutional rights, and he knows it doesn't, which is why he spent most of his time arguing that the court lacks jurisdiction over this case. Arguments, as Chief Justice Bailey pointed out, he made for the very first time on appeal. Now, because the TCPA does not apply, and because Gulf Coast presented clear and specific evidence of each element of its claims, Gulf Coast respectfully requests the court affirm the trial court's denial of Mr. Davis's motion to dismiss.
Well, counsel, let's go, hold on. Wait a minute, counsel. Let's go back to this standing. You're not saying that standing cannot be raised for the first time on appeal, are you?
No, Your Honor, that's not what I'm saying. I'm simply pointing out that these are arguments he didn't make in the trial court, and on appeal realized potentially that the TCPA does not apply to his to the lawsuit, and so he's made these new arguments. But first, I'd like to get into why the TCPA does not apply to this suit. And I'd like to dismiss any notion that the TCPA applies to Gulf Coast's negligence and negligence per se claims, negligence per se under the Water Code. So if you look at Gulf Coast petition, which determines the legal basis for the suit, those claims are not based on any communications by Davis at all. They're based on Davis's or Rio Services actions in damaging the pipeline and causing Gulf Coast to suffer financial harm. So the TCPA does not apply to those claims at all. And Davis.
Okay, counsel. Let's just stop for just a minute. What were the communications made prior to the conduct?
Your Honor, the communications that form the basis, and these are of Gulf Coast tortious interference and declaratory judgment claims, were essentially two communications, and those are that Gulf Coast could not access the easement without his permission, and that it could not install steel bollards pursuant to its right to maintain the pipeline under the license agreement. So those are the two communications at issue that form the basis of the tortious interference and declaratory judgment claims. And so the question is whether or not those communications implicate Mr. Davis's right to free speech and right to petition the government. Now, aside from the fact that the specific provisions of the TCPA that Mr. Davis cites not applying here, there are two more fundamental issues with his argument that the TCPA applies. And the first is that his argument is entirely based on the false premise that the TCPA applies simply because Gulf Coast is a governmental entity. Now, no court has ever held the TCPA applies simply based on the nature of the parties. And in fact, just 3 months ago in Blue Gold, in a case by Chief Justice Bailey, this court held that the TCPA does not apply, quote, simply based on the nature of the party's business. There must be some relevance to issue beyond the interests of the parties. So you can't just say, as Mr. Davis had, oh, you're engaged in a public service, or oh, you are also a governmental entity, so the TCPA automatically applies. You have to look further and look at the nature of the communications and the nature of the suit. And this court is not alone in reaching this conclusion. The Dallas Court of Appeals in a March 24th, 2020 opinion, in its 2020 Westlaw 1430357, that's Bus Patrol America, which was issued after we filed our brief. The Dallas court held that communications to a governmental entity, in that case, the Dallas County School Board, did not implicate the right to, did not implicate the TCPA because they were private communications about a commercial transaction. Now, the same is absolutely true in this case. The communication that formed the basis for Gulf Coast tortious interference claims and its TDJA claims have nothing to do with Gulf Coast as a governmental entity. They are based on Davis's incorrect belief that the license agreement does not allow Gulf Coast to access the easement without permission or install steel bollards. And this case Davis would take this position whether or not Gulf Coast was a political subdivision of the state. He would say that the license agreement does not give the license holder the right to build bollards. So in other words, the communications have no relation to Gulf Coast as an entity, as a governmental entity, and everything to do with Gulf Coast as a private party to a private contract. And there's no evidence to the contrary. It's all just empty rhetoric. Now here's the second flaw. I mentioned two fundamental flaws. Here's the second one. Mr. Davis has mischaracterized Gulf Coast claims to be something they're not, which is a taking. If you look at the pleadings again, which is what determines the legal basis for the action, and you construe them in the light most favorable to Gulf Coast, which the court must do, and favor the conclusion that claims are not predicated on protected expression. That's the Slope versus Rathburn case, cited at page 22 of our brief. You'll see that we have not asserted a taking. Again, Gulf Coast is trying to understand the scope of its rights under the license agreement, and that it can construct bollards as part of its right to maintain the pipeline. And if Gulf Coast is right about that, then its action is not a taking as a matter of law, because the license agreement provides that authority. Now, let me give you a case that illustrates that point quickly. And this is the Kolsch versus Industrial Gas Supply case, 132 Southwest 3rd, 494 out of the Houston First. And admittedly, this case is not in my brief. But in that case, an oil and gas pipeline operator had an easement over a landowner's property, and the easement gave the operator the right to maintain the pipeline. So after the operator constructed a block valve, an above ground block valve, which is a pipeline safety feature, the landowner sued the operator for a taking. Now the Houston court said, because the right to maintain the pipeline encompassed the right to install the block valve, the takings claim failed as a matter of law. So that's what we have here. If Gulf Coast is right, if you look at the pleading and you say, okay, it's right to maintain the pipeline under the easement, allows it to install bollards, then it's not a taking as a matter of law. So Mr. Davis has mischaracterized Gulf Coast claims to be something they're not in an effort to fit this case under the TCPA. Now, setting aside these two fundamental problems with his argument with regard to the application of the TCPA.
Counsel, is there any law that requires those bollards to be installed?
No, Your Honor, there's no state law. It's purely our contention that under the license agreement, Gulf Coast has that ability.
All right, let's carry it on a little bit further. What else could they install?
Yeah, I'm not sure that I can speculate on that at this point. I know that the Gulf Coast expert filed an affidavit, or just an email, excuse me, I apologize, saying that these bollards are minimally invasive and reasonably necessary to protect the pipeline. So I would say that as long as it fits those parameters, that it might be under the right to maintain. But again, those aren't the facts before the court, so I'm not going to. I don't like not to speculate on what else they could construct.
Well, I mean, you said they could do bollards. If they can do them, what else can they do? I mean, what can they not construct then? Maybe that's a better question for you.
Well, again, that could arise on a case-by-case basis, but the more important point is that its right to maintain has nothing to do with Mr. Davis's right to petition the government or its right to free speech, which is what is at issue in this case. So the right to petition, we talked about how it's all part of the license agreement, a private license agreement with Gulf Coast acting as a private entity. And so the right to petition provisions that Mr. Davis relies on all involve some sort of petitioning of the government for redress, and involve some sort of public proceedings. So if you look at the bus patrol case that I just talked about, the Dallas Court of Appeals, and I quote, says the exercise of the right to petition requires a communication that pertains to a governmental or at a minimum public proceeding. So again, Mr. Davis's position is that he has petitioned the government simply because Gulf Coast is a political subdivision of the state, but it's not that simple. Again, you have to look beyond just the fact that Gulf Coast is a political subdivision and see what the dispute is really about. And again, this is only about a dispute about the scope of a private agreement. And there weren't any proceedings involved when Mr. Davis told them not to install the bollards. He just told them they couldn't access the property without his permission or install the bollards. And so the right of petition can't be satisfied simply because a political subdivision of the state, which again, it is our position that Gulf Coast was not acting as in this case, is aware of and has thought about it. The issue has to go beyond that.
Well, I would think providing sewer service is a governmental function, one of the most basic governmental functions out in our part of the state. So,
Your Honor, you're correct that providing sewage services is a governmental function. But again, under the Blue Gold opinion, it can't be that the TCPA applies simply based on the nature of the party's business. You have to look at the communications at issue, and you have to look at the nature of the dispute. And this dispute is a private dispute about the scope of a contract. It is not about Gulf Coast as a political subdivision of the state. Now, turning to the right to free speech. As the court knows, the TCPA defines free speech as a communication made in connection with a matter of public concern. And then a matter of public concern includes various different topics. Included among them are economic or government or community well-being. But the Supreme Court, in a case that issued the day after we filed our brief, Creative Oil, which this court cited in Blue Gold, clarified that not every communication related somehow to one of these broad categories always regards a matter of public concern. The phrase has some sort of political, social, or other concern to the community. So the communication must have some relevance to a broader public audience. And there's no evidence in this case that Davis's communication concerned any interest beyond those of the parties. They have to do with his land, and he believes that because they involve land, it automatically involves the public interest. But this court in Caliber Oil and Gas, 591 Southwest 3rd, 226, Justice Stretcher, I believe you wrote that opinion, held not every communication about real property is a matter of public concern. Again, a communication about real property must have an impact on more than the party's personal financial well-being. And in this case, Davis has admitted that the communications involve only his personal financial well-being. If you look at page 27 of the appellant's brief, they stated, and this is a quote, they exercised their right to free speech by making communications related to their economic interests, not the public's interests. And at page 28 of the brief, they stated that the surface construction and unlimited surface access would negatively affect the economic value of Motley Capital's property, not the public's. So it can't be just that because it involves land, it's automatically a public concern. It has to involve something broader than that. And here, Mr. Davis has admitted it does not. And I'd also like to point out briefly that the environmental prong of the free speech has no application here because that's based entirely on Mr. Harris's communications to Ector County about wastewater discharge. And it has to be based on the movants communications. It can't be based on a non-movants communications. And that's under the statute. That's under the statute requires a party's exercise of its rights. And that's 27.005B. We've also cited you the case of Hardin versus Markland, 431 Southwest 3rd, 765. So it's our contention, Your Honors, that the TCPA simply doesn't apply. Now briefly, I'd like to just touch on jurisdiction because Mr. Dorfner has raised it. That the most critical issue he's raised is that whether or not Gulf Coast has standing to pursue its tortious interference and declaratory judgment claims, essentially because Mr. Davis claims it is the Gulf Coast rights are derivative of the city's, and you have to have the city involved to construe the easement. But again, Gulf Coast has a contractual right under the license agreement, and there's nobody that has disputed that. And in fact, in attacking the evidence supporting our tortious interference claim, Mr. Davis did not contend that we lacked an enforceable contractual right. So the refrain that we don't have a property right is a red herring. And in his reply brief, Mr. Davis relied on a case called the Veloceps to say that we had no standing, but that case is not applicable because in that case, the plaintiff at interest had no contractual interest in the party. And here we have a contractual interest through our license agreement. And so again, we're not trying to modify the easement or change the easement. All we want to do is get an understanding of the scope of our rights under the license agreement and obtain a declaration that the right to maintain the pipeline equals the right to install these bollards. And so at most, the city of Odessa is a necessary party, which can be joined on remand if necessary, but the court should not dismiss the action. And in our briefing, we cited the city of Bedford case out of the Fort Worth Court of Appeals, 2017 Westlaw 3429143. That was Justice Kerr, and she held that the absence of a necessary party does not deprive the trial court of jurisdiction. In his reply brief, Mr. Davis cited the case of Southwestern Bell versus Ballinger, but his reliance on that case is misplaced because in that case, the trial court had actually issued a judgment without a necessary party. We don't have that here. We're still in the early stages of the case. Now, with regard to the evidence, with jurisdiction on the negligence issue, again, we believe we have standing to pursue that because we suffered financial harm as a result of the damage to the pipeline. In particular, we lost profits on the contract we have with COG to provide it water services. So that's why we believe we have standing to pursue the negligence claim. Now, very briefly, I'd like to touch on the evidence supporting our tortious interference claim. Again, it is Mr. Davis's contention that the right to maintain the pipeline does not include the right to install bollards. But if you look at the case, if you look at the common definition of the word maintain, which means it means to keep up, preserve, bear the cost of, or keep unimpaired, keep in good order. And this is from the Texas Supreme Court case of 3 Welding Equipment versus Kutcher, Rolfs, and Cummings, and that's 229 Southwest 2nd 600. And again, if you look at the Coles case I cited you out of the Houston Court of Appeals, the Houston court determined that the right to maintain meant that the pipeline operator could install the safety block valve on top of the pipeline. So in argument to the contrary, Mr. Davis has said that Gulf Coast cannot engage in surface construction because paragraph 7 of the license agreement says that it has to return the property to its pre-construction state. But what he's left out is that it says the property has to be returned to its pre-construction state as nearly as practicable. So that paragraph actually contemplates some sort of construction. And Davis has also claimed that it was not necessary to install the bollards as part of the protection, but we have evidence on that we cited in our brief. And then finally, I'd like to just touch on briefly the issue of attorney's fees. So it's clear that the TCPA has no application to Gulf Coast negligence and negligence per se claim under the Water Code. It only applies, if at all, and we don't believe it does, to the tortious interference, the declaratory judgment, and the request for injunctive relief. So if you were to find that the TCPA applies to those claims and that Gulf Coast has not presented clear and specific evidence of those claims, the court can't award the attorney's fees. And here's why. Because the evidence that Mr. Davis had in the trial court was an affidavit from one of their attorneys about the fees that they incurred didn't segregate between the recoverable claims and then the water code and negligence claims, which fees are not recoverable because the TCPA doesn't apply. So you'd have to remand that issue back to the trial court. So in conclusion, Your Honor, we believe that this is an improper use of the TCPA to deny Gulf Coast its day in court, to have a court of general jurisdiction construe and interpret a private agreement. And for that reason, Your Honor, we'd ask that the court affirm the trial court's denial of Mr. Davis's motion to dismiss under the TCPA.
Okay, counsel, you've got about 40 seconds before you wrap it up. Your position is there's no public component to any of these communications, period. It's just a private matter controlled by Caliber.
Yes, your Caliber and also Blue Gold, Your Honor. It is our position that the communications at issue, although there's some, it appears as if there's a public aspect to it because of the nature of Gulf Coast and the services it provides, but the communications at issue don't have any relation to that. Instead, it's a dispute about the scope of an agreement. Thank you, Your Honors.
Thank you very much. Mr. Dorfner, we'll now go to you for a brief rebuttal. Mr. Dorfner, you're muted.
I promised myself I wouldn't do that. I want to start where opposing counsel ended, and that is in response to Justice Stretcher's question about the public component of this communication. First of all, the TCPA does not distinguish between public or private communications so long as those communications have a connection with the right to petition or a matter of public concern. The Supreme Court held that in Lippincott. This court held that in ETC Texas Pipeline. Gulf Coast is not a private party. The correspondence and the pleadings all assert that Gulf Coast is acting as a political subdivision. It's using its status to obtain the results that it wants. This is not a private contract. This is a public contract pursuant to an interlocal agreement. There's a license agreement between the city of Odessa on one hand, a municipality, and the Gulf Coast Authority, a political subdivision on the other hand. This is the nature of the license agreement is the disposal of Odessa's public wastewater. This is public and not private any way you look at it. Two governmental entities contracting pursuant to an interlocal agreement to dispose of public wastewater. So in that way, this is a very public contract. This is a private citizen who's speaking against the government's use of his property. That is a very public concern. In the state of Texas, and I'd like to believe in other states in the union, the right of private property ownership and the right to tell the government, no, you can't take my property is held inviolate. This has been a matter of public concern for hundreds of years. We can see that reflected in the recent constitutional amendments. We can see that reflected in the Texas Landowners Bill of Rights. There's a process that needs to be followed when a governmental entity wants to use or take someone's property. They just cannot do that. And when Mr. Davis told the governmental entity, you can't do that, he was speaking about a matter of public concern, not only the matter of the government overreach on his property, but also the economic impact to his property, to the economic impact of a lot of people's property, because if the Gulf Coast Authority can do it to Mr. Davis, he can do it to other people as well. The TCPA applies to public or private entities. So even if the court was to consider that this was an action as a private entity rather than a public entity, in the Hirsch versus Tatum case, the Texas Supreme Court talked about as long as the speech is based on, or as long as the communication is related to the right of free speech and the right to petition, the TCPA applies. It doesn't even matter if this was actually a taking. We contend it is, but as long as there is a connection, a communication about the right to petition and the right of free speech, the TCPA applies. The question for the court is, were the defendants sued for protected communications? We look at the petition. Absolutely, you can draw a direct connection, even in the plaintiff's words, why it was sued. It was sued for denying Gulf Coast's rights to the property. And briefly, in the last minute or so that I have, I want to talk about the fact that the Gulf Coast Authority was a licensee. This also has to do with standing. A licensee is an entity with, or a person that's given a very limited privilege. It owns no property rights. If the court allows the Gulf Coast Authority to bring a suit on behalf of, standing in the shoes of, or related to Odessa's contract to its license, it would be making licensees the de facto agents of the licensors. That goes against well-established property law, that licensees merely hold a privilege to do something. So we would ask the court to find that the TCPA applies. Mr. Davis's communications directly implicate the right of his free speech and the right to petition.
Thank you very much, Mr. Dorfner. Gentlemen, your case has been submitted. The court will be in recess until 11 a.m. Thank you.
Thank you, Your Honors.
Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas is now adjourned.